Welcome back to Financial Fortitude, the podcast that helps high earners, families, and business owners live well today and plan wisely for tomorrow. I'm your host, Michael Acosta.
And I'm Brady Hemmerly. Today, we're diving into a topic that's emotionally charged and financially complex: divorce. Most specifically, what you need to know when it comes to personal and business finances if you or someone you know is going through a separation or divorce.
And joining us today is Sabreena Barboza, founder of Barboza Law in Rock Hill, South Carolina. She's a powerhouse family law attorney who's seen it all and is here to help us unpack the financial pitfalls and planning opportunities that need to be considered if going through a divorce.
So whether you're a business owner navigating separation or a spouse unsure of your financial standing, this episode's for you, and let's dive in.
Welcome to Financial Fortitude, a podcast for high earners, families, and business owners. We are your hosts, Michael Acosta
and Brady Hemmerly. Each week, we bring purpose-driven financial guidance to you so you can be assured you're on the right path. If you're looking to become an extraordinary wealth builder, let's dive in.
Now, Brady, this is a unique topic, right? I think we start most of our episodes saying that we're very excited to riff on a topic or break down a topic or a headline. This one, I would say, is probably less exciting only because it's not something that most of us who are married already or who are in a serious relationship and planning on getting married think about coming to reality, right? I would say most couples don't get married with the idea of, hey, this might fail. Like, we're probably going to get a divorce in a couple years. Would you agree with that?
Yeah, every marriage does not come with an expiration date, at least when we're joining or signing the contract together at first. Right? Every marriage is supposed to last forever, but what we know as financial advisors, and I'm sure Sabreena can shed even more light on, working in this legal space is, hey, a lot of marriages do come to an end, some sooner, some later. And it's not exciting when that happens, right? It's usually unpacking a life's worth of complexity and trying to figure out, hey, where do we go from here?
Right.
So excited to share and learn more about this topic, but not necessarily excited for the weight of the topic itself.
No, correct. And before we allow Sabreena to introduce herself, I think it's worth setting the stage of kind of what's prompting this, right? There's two specific articles that we're going to be referencing here. One from Investment News back in 2024, and then one more recent from May of this year with CNBC. So if we're going to reference one of the first articles being Investment News, which has the title, "A Poll of Divorced Americans Sheds Light on the Role of Debt and Separations and the Financial Fallout for Divorce," it states that in the poll that they conducted, there were 526 divorcees. 1/3 reported credit card debt and financial infidelity as being critical factors in the result of the divorce. About 70% of the respondents cited credit card debt as a reason for their divorce, and also mentioned that they or their ex-spouse had concealed the debt. And then about 80% admitted hidden spending played a significant role in their separation. So if we just unpack that, I think it's, one, knowing your spouse before you get married, right? That's obviously important. But then even after saying I do and coming back from the honeymoon, it's what open lines of communication are taking place and are both spouses involved in managing the finances, which we often find isn't always the case.
Sure. And I think a lot of times it's because your financial picture is going to be a very intimate piece of your overall relationship, fulfillment, happiness, quality of life, right? As much as we don't want to say it, money does matter when it comes to a lot of these things. Having enough, managing it well, being on the same page. So with our podcast, of course, being financially driven and here to provide as much financial education as possible, right? It's important that people understand, hey, before that they tie the knot, that they know what they're getting into from a financial perspective and with their partner and then just in general.
And if I'm going to then reference now the other article with CNBC, so this one's titled, 54% of people believe a partner with debt is a reason to consider divorce. Here are other ways debt may affect your marriage. And again, this was from May 1st of 2025 this year. One specific piece of this that stood out to me was that it states that people have such a strong negative feeling around debt that 3 in 5 Americans have considered putting off marriage to avoid inheriting their partner's debt. According to the same study, and what's more is that 54% of respondents believe that having a partner who is in debt is a major reason to consider divorce. Now, I know a lot of our listeners have 6 figures in student loan debt, right? Often, because, a lot of times it's medical professionals, attorneys, or maybe someone who took out loans and decided to go do something else with their career and they're still dealing with that, right? Other times it's individuals who made a really bad decision on a car purchase or maybe even a home purchase. And sometimes these actions or these events take place before the marriage actually happens. And so if we peel back this article a little bit more, just looking at some of the key components around sentiment with debt, they talk about how in marriages, disagreements on how to spend money is a big thing, right? And we did an episode early on at the onset of our podcast, that just talks about financial independence when going from being independently managing your finances to then joining them, right? I think the episode was top things to consider after saying I do. So if you haven't listened to it, if you're a new listener, go back and listen to that one. Other things that's already been mentioned from the investment news article, financial infidelity and secrecy around spending. I think it's somewhat inherently from a human perspective that if we feel shame in the way that we're spending money and we think very highly of our spouses or our significant others, we probably don't want to share how lackadaisical we might be or how badly we're utilizing the money that we're earning together.
So it's clear that debt is a driving factor. Individual management of finances might be a driving factor. And there's a lot of real emotional drivers of the financial picture that can lead to divorce. And I think that well transitions to bringing in our esteemed guest, Sabreena, here to give us a little bit of background as to what her work looks like, the type of clients that she works with, how she got into this business itself. And then I'm sure we can unpack more of the specifics. Hey, what do divorcees need to know, or someone considering a divorce, what do they need to know? So Sabreena, welcome.
Hey guys, thanks for having me. Yeah, so like Michael said at the beginning, I've founded Barboza Law about 3 years ago in 2022. But prior to that, I worked for a firm where they primarily practiced family law. But my first few years out of law school, I was doing criminal prosecution. So when I left the prosecutor's office and went to work for a private firm is when I really got into the family court realm and started researching the statutes in the state and figuring out what does divorce or separation actually look like. Now I'm about, 4 or 5 years in, and my practice is about 70% family law, I would say. And to answer your questions about the types of clients, they change, right? Every situation is going to be different, but we have people from, young, just few years into their career getting divorced. We have people that are, several years, maybe one child getting divorced, and all the way to what they are now calling gray marriage, which is new, and the rates are really skyrocketing since COVID, which is, people in their 60s or 70s now deciding to divorce or separate, which obviously are going to be more complex cases because the longer that you're together, it's implied, it's not always the case, that, you'll have either more assets or more debts. So
Sabreena, I guess the first question that I have for you, just speaking generally, when you are meeting with new clients, how often is financial management or the finances in some form or fashion a driver of divorce or a major butting point or butting heads point in the whole process?
yeah, I would say it's not often where people are coming in and their specific reason is some type of financial abuse or financial debts being hidden or things like that. Most of the time it's going to involve years long of other issues. But in regards to the consultations, every single divorce consultation is going to address what their equitable estate looks like. And what that means is all of their assets, all of their debts. And that starts from simple things as what their W-2 or their 1099 income looks like, all the way to, do they have a golf cart? Do they have a boat? Everything that you own from the date of your marriage until the date that you actually file is marital. So sometimes people come in and they just want to know, what does it look like? They haven't decided are they going to file or not. And that tends to be the older generations that are coming in to say, okay, what am I really looking at financially if we separate?
Yeah, because it almost becomes some sort of mathematical equation to say, okay, well, I guess it's a combination of mathematical and emotional equation. It's the combination of, from a financial perspective, what's the output if this divorce does go through or the separation does go through? Or emotionally, can I continue to withstand being in this relationship so that mathematically it doesn't completely ruin me?
Exactly.
Yeah, that's tough. You brought up the point of assessing everything on the balance sheet from a financial perspective. And early on, as we were talking before we started the recording today, you were talking about how, a lot of people have a understanding of, marital versus separate property. And do you feel like when you sit down in those initial consultations or mediations that it's a really tough sticking point for the individuals, the couples, because maybe they misunderstood what was going to be considered theirs versus what they would be required to split?
100%. Be honest with you, probably 99% of people outside of the legal profession, obviously, have no idea what is theirs and what is theirs or what is mine or what is ours, because there are so many exceptions to the general rule. So that's why a lot of the times when they come in and we go into depth, they walk out informed, but definitely surprised.
So let's use an example here. Let's say I'm one of the younger professionals. I'm recently married, maybe 3 to 5 years in. I'm in the early stages of my career. My significant other and I have each brought our own bank accounts, our own retirement accounts, our own investment accounts into the marriage, all of which was mine and theirs to begin with. 3 years go by and now we're divorced. When that situation happens, how do you begin to unpack, all right, well, what was mine beforehand versus what is now maybe ours ongoingly? How does that look?
Yeah, that's a great question. So the first thing that we would ask for is, what is your date of marriage? Because a lot of the times people are like, we've been together for 10 years, but we've only been married for 3. The length of your relationship is irrelevant. It's the length of your marriage. The first thing we're going to find out is, when did you guys get married and have you separated? Are you still living in the same house? Because in the state of South Carolina, if you're sleeping under the same room or you're engaging in asexual intercourse, your date of separation starts all the way over. So it's important for us to clarify, when have you separated? And then at that point, it's, has anything been filed? Sometimes people come in and they are the defendant, and that is the person who's been served with the divorce papers. Or a lot of people, some other people come in and they want to be the one to file for divorce. So it really is going to depend if you're the defendant or if you're the plaintiff. If you're the defendant, then there's been a date of filing, and it's extremely easy for us at that point to say, okay, you said you came into this relationship with this checking account at Bank of America, this savings account at Wells Fargo, and these retirement and investment accounts at Fidelity. What we're first going to ask is, give us all those bank statements as of your date of marriage, because what those account values are as of the date of marriage are separate property. Then we ask for your most recent statement and or your statement that is the closest to the date of filing. And that tells us what the values are now. And then with checking and savings, those are relatively easy. This is what it was. This was what it is now. So the present value is $100,000. You had $50,000 premarital. $50,000 is marital.
Okay.
Does that make sense?
Yeah.
Oh, it does.
Yeah.
With retirement and investments, it can get very complex the more in depth people want to go. So you can also do it very simple, retirement and investments. This was his balance, $100,000. This is his balance now, $50,000. $50,000 is marital. But in retirement and investments, you start dealing with interest. And then the argument is what about the interest that you are getting on the money that is premarital, but you're getting that benefit during the marriage, right? So that's why it does matter, and it can get very complex.
So follow-up question there is, what is the impact of that separate property versus marital property? Is that treated differently through the divorce process and then after said and done?
Yes. So anything that is considered to be separate property, the family court does not have subject matter jurisdiction over. So anything that you owned at the date of your marriage is yours and will always be considered to be separate property. But the day you're married and every day forward, until you have filed for legal separation and or divorce, is all marital. So again, in that situation, if he has $100,000 as of the date of filing and he had $50,000 as of the date of marriage, only $50,000 of that is subject to the divorce and the equitable distribution of the marital estate.
Per South Carolina, of course, right?
Yes, per South Carolina.
Yep.
Now, I am curious, how does that work? I mean, I'm sure it's relatively the same, but using a different use case example, like let's just say that prior to marriage, both of the spouses worked in the workforce, were deriving income. They get married, they start having children, and one of the spouses becomes a homemaker. So now there is no income, right? but most of the assets, I guess, are titled jointly. So I guess same concept, right? So fast forward 3, 4, 5, 8 years, the non-working spouse or the spouse that's not working out of the household, I guess they have access to 50% of anything that's been jointly accumulated from the time that they said I do moving forward, correct?
That's correct.
Okay. Now, I think a big sticking topic, though, is probably, well, let's talk about the retirement aspect of it, right?
Okay.
Because in that scenario, you might have the non-working spouse, the homemaker, who isn't necessarily maxing out their retirement plans, right? Maybe the working spouse is able to make contributions to their retirement plan, like as far as like a Roth IRA or a traditional IRA. So if the working spouse is maxing out their retirement plan and it's pretty sizable, from a splitting of that asset, that's where I imagine the qualified domestic relations order or the QDRO comes into play, right? Basically, whatever the court deems is due to the other spouse.
Yes, that's correct. So if it's an investment account and not a retirement account, or QDRO is not required if the other party just has to open an investment account, because there's not going to be any tax issues or tax problems with that. So you just can transfer. Retirement specifically is when the QDRO would come into place. And like you said, in this situation, it's very common, especially, living in South Carolina, where one party is going to be the housemaker and one party is going to be working. So it does result in one party contributing to the 401k and maybe one party not. And what happens more often than not is the non-working spouse doesn't understand that although that retirement is in the working spouse's name, half of that is still theirs. Now, I want to say that it's not technically half, right? South Carolina is an equitable and fair state. That is the standard for the division of marital property. So what that means is most judges are going to defer to a 50-50 split absent a fault basis for the divorce, because that's another thing that comes into play that affects the finances. Is this just you guys have grown apart, or is this someone has committed adultery, someone has, a habitual drunkenness issue? That will also affect it. But generally speaking, just someone that is separating because they no longer believe that their marriage is healthy, they don't realize that that is also theirs. And most of the judges are going to defer to a 50-50 because that's what they believe to be fair and equitable.
Let's say the breadwinner is a business owner, right?
Okay.
In that scenario, if it's 100% owned by the business owner, single person LLC, 100% owned by the individual, and their spouse has no ownership equity in it, no part in working in the business, what happens then with the valuation or equity in the business for the non-owning spouse during that divorce? Is the equity in that business susceptible to being split, or because it's solely in the one spouse's name, it's somewhat sheltered?
The first question would be, when was the business formed? Was it formed during the marriage or before the marriage? If the business was formed during the marriage, the same thing would apply. It doesn't matter whose name it is, it's a marital asset. But let me get more in depth with that. The next question is, what is the business? Can it be valued, right? And two good examples would be, for example, me. I own a law firm. Can my law firm operate without me? And the answer is no, I am my law firm. Right. But if I owned a porta potty business, and if you took me out of the equation, could my business still run? And the answer is yes. Someone could take my position and run the business because it's a porta potty business.
Right.
So that is going to be determined. Can the business be valued? If the business cannot be valued, then the business is not going to be subject to equitable distribution because it doesn't have a value. Now, that is going to be separate from business assets and debts, though.
Got you. Now, who determines whether or not that business can be valued? Like, does the court deem or require that the owner have to go out and meet with like a mergers and acquisition company to get an appraisal done, just like you would for a home if you were going to get the home appraised for some sort of value?
Most of the time, no.
Okay.
I mean, it's a pretty simple question, and that's kind of the unspoken rule is, can this be valued? Are you your business? Because if you are, then all you have to do is quit your business and the business closes.
Right.
So it comes down to more of like common sense, and then you determine if it needs to be valued.
Gotcha.
So let's say Michael and I are business partners and our business can be valued. We run the porta potty business. He does the marketing. I do the operations. Now there's two of us involved. And in this example, my spouse and I are getting divorced. So how does my life change affect Michael, or does it at all?
That's actually a great question. And that doesn't come up often. But in this situation, we have two business owners, which would be you and Michael. You own 50% and Michael owns 50%. Is that correct?
Yes.
Okay. And you and your spouse are getting a legal separation. Well, first and foremost, your 50% of the business is going to be subject to equitable distribution.
Okay.
Michael's portion would not be. However, in order for the court to even touch the business, we would have to add Michael as a party to the divorce because it is also his business. Now, that doesn't always happen, but that is the proper way to do it. But yes, it would not affect Michael's life, but it would affect yours. Say, for instance, we got it appraised and it came back, again, simple math, $100,000. Your half is $50,000. Your spouse is entitled to half of that, which would be $25,000.
Sure.
Now, I can assume your next question would be, well, does that mean I have to sell my business? Right? Because that's what people would start freaking out. Does that mean I have to sell my business? And the answer is no. Could you have to sell your business if you and your spouse are so unreasonable that you can't agree on anything and you go to court and the judge says, you know what? Sell it all. Sell it all and split it down the middle. The judge could absolutely do that. But most common thing is, okay, you know that you owe your spouse $25,000 from your business. You can make that up in from an investment account or a retirement account. It does not mean you would have to sell your business.
And one thing I would add to that for the business owners that are listening, one thing to be aware of is that a lot of businesses can be valued and a lot of business owners think that maybe their business isn't worth anything. And so if you're one of those business owners, regardless of whether or not you're planning on getting a divorce, it's worth going out and talking to someone who specializes in business valuations or business exit planning to be able to get some guidance on what your business might be valued at from a business equity perspective. Second, if you do catch yourself in this conundrum, right, hopefully you own something a little bit more attractive than a porta potty business. Brady, I wish you would have picked something a little bit better for that example, but I understand why you picked it. And let's just say you're the partner who is going through the divorce and you owe your spouse $25,000. Well, there are other ways, right? Like Sabreena mentioned, you can pull from outside assets to make up the shortfall so that you don't have to touch the business. You can go out and obtain a working capital line of credit. You can potentially even take a loan against your 401k assets if necessary, right? There's pros and cons to everything. There's a ripple effect on your balance sheet and your business balance sheet to every decision that you make. But this at least clears up that, hey, you don't have to necessarily sell the business to meet the demands of the court. So there are ways to get creative, and that's where having the right people on your team, like a trusted attorney as well as a financial representative, that can be very valuable to you in your situation.
So up to this point, we've begun to explore the difference between marital and separate property, right? Marital property is assets that I've accumulated while married, whereas separate property is assets that I had accumulated before marriage. Whether it's retirement accounts, investment accounts, cash, business, right? They're all treated in a similar fashion. And the main goal is equal, fair distribution in a divorce situation. I think one of the things that we haven't talked about yet, and Sabreena, I'd love your thoughts or what you've seen here. Assets are one part of the equation, right? That's what we own. But for most clients, especially those that are still in their career, cash flow, the money that they're making and living off of, is a huge component to what their world and quality of life looks like. So how is cash flow, equitable and fair distribution calculated? What are some things to consider when it comes to things like alimony payments, child support? Like, how does that all work, especially if spouses aren't earning exactly the same salary?
And I'm sure that has your listeners gone, oh my goodness, what did I get you? And I'm just kidding. But that is a great question because, again, people don't realize, yes, it is your career, but the money you make during a marriage is a marital income. So, yes, it might say Brady's name on the check, but in reality, when he puts that in the bank account, that becomes Brady plus his spouse. So to answer your question, first, we can address alimony. Unfortunately, in the state of South Carolina, there really is not a straightforward answer on that. every judge is going to determine a different alimony number. And that's the unfortunate truth. There are, of course, going to be factors that the court has to take into consideration, such as the income that the both spouses have, what was their contribution during the marriage, what does their finances look like after the equitable distribution, how long have they been married. There are several things that the court has to consider, but there's not like a calculator, okay? Brady makes $100,000, his spouse makes $50,000, and they've been married for 8 years. Calculate. That does not exist in the state of South Carolina. Maybe it does in other states, and if they have it, I hope they send it to us because it would be great. Because that is probably one of the hardest part of my job is giving someone a realistic expectation of what they could be paying in alimony or spousal support and or what they could be receiving. Now, I will follow that with, in the counties that I practice in, we have kind of created our own little formula that I think the judges, just based off our experience and the numbers that we see, but again, they're not concrete, because the other issue is when you go to court, you're not guaranteed to get a judge that's from your district. Family court judges travel throughout the state. So that's the other thing too, is when you go to court, you don't know, is your judge from Lancaster County? Is your judge from Greenville County? And do they do things differently up there? And the unfortunate truth is sometimes I don't know the answer to that, right? So there is no way for me to give them an exact answer. But what I will say is the formula that I believe is kind of fair is something like this: Brady's income minus spouse's income times the amount of years they've been married, and it gives you a number. And then what I do is I would back off 0.66 of that. And that kind of gives you a range. That's where I can go to my clients and say, this is on the low end, this is on the high end. Now, where this question becomes more complex is it a long-term marriage? Because in the state of South Carolina, once you're considered to be a long-term marriage, you can get into what's called equalization of income as alimony or spousal support, which it can be as drastic as Brady makes $50,000. His spouse has been a homemaker for 30 years. She has no college degree. She has no
work experience.
Work experience or licenses. So the court says, well, we're not just going to leave her high and dry, right? You decided to marry this person. You decided for them to be your homemaker, to raise your children, to, keep your home a happy place to come home to. And at that point, the judge might say, look, I don't know what else to do. And what's fair in this situation is for her to live the exact same way or he to live the exact same way you are. Now, that's drastic, but that can and does happen, especially in those longer term marriages.
So I'm curious, what's considered a longer term marriage? Is it set in stone or is it pretty gray? Is it very subjective to the views of the court?
Yeah, I mean, that's another great question because that's another very common question. The truth is, if you're at 10 years, you're a long-term marriage. And you need to start really understanding that if you get separated and you are the primary breadwinner, you are looking at permanent and periodic alimony. And what that means is that is forever. Unless the non-paying spouse gets remarried, the non-paying spouse or the paying spouse is deceased, and or the non-paying spouse is living with the romantic partner for 90 consecutive days. Which again, that can be very hard. How do you prove that they're living with someone for 90 consecutive days? Are you going to put a private investigator outside their door? How do you prove it? But I can say in my experience, I have proven it, and it can be canceled. It can be immediately stopped if one of those three things happen. But 10 years plus without one of those three things happening, you are looking at paying your spouse forever. And that is one thing that is going to be state by state. So if you don't live in South Carolina, that might not be the laws of your state, but specifically for South Carolina, once you hit a long-term marriage, it's a permanent and periodic state. But to answer your question, it's really, the gray area is 7 to 10.
Gotcha.
But once you are at 10, you need to realize that you're a long-term marriage.
Gotcha. And then can you elaborate for us and maybe for the listeners as well who aren't familiar with this entire process and some of the terminology as far as the differences between alimony and child support?
Of course. Yeah, that's a great question. So alimony is specifically for the spouse, the person that you were married to, the person that you created a life with. Child support is completely separate. If you come to the unfortunate reality of a legal separation and or a divorce, and there are children involved, it not only becomes emotionally harder, but the truth is it also makes it more financially harder,
Right.
especially if we're going to keep the same scenario of we have one business owner, that's the breadwinner, and we have one person that's a homemaker. If you keep the same scenario, the first thing that you're going to do is you have to create an alimony number if alimony is applicable in the case. And the reason why is what's different between alimony and child support is we actually have a calculator. You know, South Carolina Department of Social Services created a child support calculator where it is a plug and play calculator, and there is no way that you can change what you're legally obligated to pay for your children.
Yeah, there's no way to fudge those numbers.
Exactly. Unless the parties agree to deviate, and does happen. But some of the questions they're going to ask is one party paying alimony? Because if you're paying alimony, it is going to reduce your child support because that's an additional income that the non-breadwinner spouse is going to receive. So the main questions that they're going to ask are, how many overnights are each parent going to get? Yes, you heard that correct. Child support is really determined on how many overnights each parent is getting. And what that calculator is looking for is this a shared visitation schedule, or is this one party has the children more than the other? Because that is going to affect how much child support you're paying, because obviously if you have the children more, you're going to be paying for their everyday needs of food, school supplies, clothes, just as much as the other parent. But if it is a situation where one parent has the children more than the other, that the parent who has the children less is going to have to provide more financially.
Gotcha.
So that's the first question. Then the second question is there any other children in either parent's home other than the child or children that are subject to this calculator? Meaning, does your spouse have two children from a previous marriage? Or have they had a child since you guys separated? They would get a credit for that. Do they have any other court-ordered child support or alimony from a previous marriage or from a previous child? And then lastly, who's going to be the primary parent? AKA, who is going to be the one to claim the children on the taxes? Because the parent who's going to claim them on their taxes obviously is going to get the benefit of the tax credit at the end of the year.
Right.
That's also taken into consideration. So once you answer all of those questions, you hit calculate, and at the bottom, it tells you who's paying your child support, how much that would be on a weekly, bi-weekly, bi-monthly, or weekly schedule.
So let me ask you this, and let's use a case study here. So let's say that husband and wife and both professionals working out in their careers. Let's say that the spouse makes about 1.5 to 2x more than the husband. They have a child. They've been married, let's call it 6 to 8 years. And they own a home together, right? They've been planning together. They've been working with a financial advisor, saving diligently, building money together in joint accounts, as well as their own individual retirement accounts. And let's say that they've been going through the process of separation, which I think is going to lead to another question here in a little bit. But the plan is that one spouse is going to have to rent somewhere else. And let's just say it's the husband who's going to be renting somewhere else who makes less. But they're going to have split custody or joint custody. So in a joint custody situation or split custody, is it presumed that each parent is going to have the child stay with them, 365 days in a year divided by 2, just split down the middle? Like, is that the presumption?
If it's split custody?
Yes.
So first and foremost, this is kind of like a puzzle, right? They own a home together, so we know that we have a marital asset. They have a child together, so you know that child visitation and child support are going to come into play. And then lastly, you know that they're both working. They've been married for 6 to 8 years, and one makes more than the other. So you're dealing with 3 different things at that point. Is alimony applicable? Is child support applicable? Which the answer is always yes. And what are they doing with the marital home? In regards to alimony, 6 to 8 years, she makes twice as much as him. It would really come down to more of probably rehabilitative alimony. For me, that would be my argument. In 6 to 8 years, I don't believe that's truly a long-term marriage. They have one child, she's 5. I would argue no alimony. And if any alimony, rehabilitative, meaning I'll pay him alimony for a year to help him get on his feet. He can look for a better job. He can do those things. But after a year, that's on him. Now, the better question you ask is, what if they literally said, split it down the middle, week on, week off? then what would happen is you could still put all those numbers into the child support calculator. And it is more likely than not that she would still have to pay him child support, even though they have a 50-50, because the child's way of life at one parent's house, the court wants it to be as close as possible at the other parent's house.
Equitable on both sides from a living experience perspective.
Exactly, for the child. Now, what does happen often is the parties agree to deviate from those and say, if we're doing 50-50, you pay when it's your time, I pay with mine. But legally speaking, it could be that she ends up paying him child support. And then lastly, what's happening with the house? Because a lot of times it would be, okay, let's calculate this child support. If it's a 50-50 split and she's supposed to pay you $200 a month, your daughter's 5. So let's say you have 18 more years of $200 a month. So 200 times 12. And then we said, how many more years? 13 years? We're looking at $31,200 over the course of your child's age until they're a legal adult, which is 18 in the state of South Carolina. So you might say, okay, I don't want child support, but I want an extra $50,000 from the house. You technically shouldn't be negotiating these things, but sometimes it makes more sense. Mom might say, I'd rather give him more money now from the house because I can recoup that,
right,
than have to pay a monthly thing. So the good thing is, if you and your spouse can be amicable, you can truly agree to whatever you want, as long as both parties believe it's fair and equitable and in your child's best interest. It's rare that the court is going to get in the middle of an agreement that the parties who are actually the ones in their life and in this lawsuit agree. But the unfortunate truth is, when you can't, is when you let somebody in a robe that doesn't know you, doesn't know the other person or your child, make those decisions. And at that point, it's just black and white.
Gotcha.
And the law is the law.
So what I'm gathering from this entire discussion is, number one, the entire divorce process can be very much a gray area. And then number two, the way that these negotiations go oftentimes feels more like an art just as much as it might a science. And then number three, this already feels, I'm not going through a divorce right now, but this feels overwhelming just listening to it. How many decisions that I have to consider, how many different ramifications might come of any strategy decision that I'm making. And so right away, what I'm thinking is, hey, this is not anything I could navigate on my own. It's time to get an attorney involved. So Sabreena, can you share a little bit more about what clients can do who are either going through this process or thinking about going through this process? What can clients do to begin to get organized, to gather their needed documents, and what can they expect from a cost and a time perspective through this process?
I always advise people to do, and most people don't do this before they come and meet with a lawyer, but if you're listening, what I would suggest is to start collecting all of your financial documents at your most recent statements. And if you can identify what you believe to be separate property, I would begin collecting those statements as of the date of marriage to get the value of the separate property at the time of the marriage. And I would also advise, making a decision with an attorney, bringing those documents in and really looking at what your marital estate looks like. And in regards to how long and the cost around that, this is another question that people ask, and it's really hard to answer. Your divorce can be as costly as you and your spouse make it, and it can be as inexpensive as you and your spouse make it. If you're willing to be amicable and know that nobody is walking away from a divorce happy, right? It's very rare that both parties walk out of a room and they're like, yeah, so glad that happened. You are going to lose money. You are going to lose quality time with your children. And that's why when people come and meet with me, I always tell them, you didn't make a decision to get married quickly, and it shouldn't be a decision to get a divorce or a separation quickly either. Because like you said, it's very overwhelming, not only emotionally, but also financially. Because what family law is it's a retainer. It's a billable realm of the legal field where you pay an attorney a retainer. That retainer goes into a trust account, which is, I explain it, essentially a savings account that your money goes into. And as I earn it, I pull it from the trust account into my operating account. And my hourly rate is, let's say my hourly rate's $300 an hour. You get an invoice the 15th and the last day of each month, and you have to maintain at least $1,000 in your trust account at all times. So if I'm working to draft motions, fight motions, argue about this, fight about that, I mean, could spend over $100,000 on a divorce. If you both come to the table with the realization that this is going to be hard, a divorce could cost you $3,000 to $5,000. It really all depends on the parties that are going through the legal separation or the divorce.
Now, is it recommended that each party, if they're going to take these steps of separating and then going through a legal divorce, that they each have their own form of representation? Or are there situations where a single family attorney might be able to, work with both from a mediation perspective just to keep the costs low for them if they can be amicable and realistic?
Of course. That's a great question. Like, for example, at my law firm, we offer flat fees for uncontested divorces. And what is considered to be uncontested is both parties come and meet with me. They tell me, this is what we have, this is what we want. All we want to do is what we're entitled to. I talk to them about it. I draft it up. And you don't need to have representation on both sides at that point because you guys know what you want. No one's going to convince you otherwise. And my job is to ensure that that's drafted up into a court form that will be acceptable by the court and to walk you through the process to ensure that everything is done properly to ensure that you are actually divorced at the end of that.
So I have a follow-up question to that just because my mind works in a weird way. But so they come in, they say, hey, Sabreena, this is what we want to happen. We've, assessed all of our assets. We believe that this is fair. You take that, you draft it up based on what would be approved or allowable in the court of law in the state of South Carolina. If you recognize that, hey, this isn't really as fair as one partner or spouse might think it is, like if you think that one partner is being unjust or unreasonable and is pulling a fast one over the other spouse's head, do you then take it upon yourself to consult, or is that not really your role in that situation?
Specifically in this role as an attorney, technically speaking, I only represent the interest of the party who pays me, and I can only accept funds from one party. So if I review it and it's my client and I think they're getting a wool pulled over, I'm legally obligated to bring that to their attention. Right. The other side is I don't have to, but I would, because when you go to court, the court is not going to accept an agreement that says husband gets all the houses, wife has to be out in 30 days, and she gets $1,000 check. You know what I mean? The court is not going to accept that. So it is important, although I'm not legally obligated to that person, I still am an officer of the court and need to ensure that a document that I'm presenting to the court is something that I believe a court would consider to be fair and equitable.
Gotcha.
And that would be something I would address with my client and say, hey, I'm letting you know I don't think this would get approved. Now, it's your call, but I'm telling you, if you go into court, you might end up, the judge is going to look at your spouse and say, are you crazy? You should walk out. And this does happen. The judges will blow up an agreement. And not only have you lost the trust of your spouse, but now they're getting an attorney and you're most likely going to war, right? So I always tell people it's important, if you want to be amicable, that you're open and honest about the process, whether or not they are represented, because it can and it does blow up. Family law is very unknown. Maybe one day someone signs an agreement, they wake up the next day and they freak out, they regret it, right? There's so many different things that can come up in family court.
So Sabreena, here's a question I know that we haven't yet covered, right? Up to this point, we've covered marital versus separate property, how businesses are involved there, what cash flow looks like, how arguments and perhaps agreements may look over time, fair and equitable. The one thing that we haven't covered, and it's interesting because it's one of the main drivers that we had read in our articles above from Investment News and CNBC, how does debt get treated in a divorce? Because that's a much messier subject, and I'm sure a much more emotional subject for clients.
And that's absolutely right. The debts and the assets work the same exact way. It's a simple answer. Anything that is either accumulating in regards to accumulating money or accumulating debt from the date you are married until the date that you file for legal separation or divorce is marital. And that is whether that one spouse knows about the debt or the other party is actively concealed it, unless there is a way to prove that they were using the money in a way that was not beneficial to the marriage, it's going to apply the same way. And an example of spending money where it's not a benefit is one party addicted to a pornography site and they've spent, $7,000 over the course of 1 year on a pornography site. it is very likely that a court might say, that's your debt. That is not marital debt. You did not go into this debt and your spouse benefited from it. But if your spouse racked up $7,000 in debt to buy toilet paper, to buy food, to take the dog to the vet, and you don't know about it, the truth is that's unfortunate because you benefited from that. You were maintaining your way of life. So that is the only way a debt would not be the same as an asset, is if you can show the court that this was a decision made entirely about and for the individual and you no way benefited from it.
So the last question that at least I have, and Michael, feel free to jump in with any other questions, is, as messy as this process sounds, as long as it can be, as argumentative as it can be, what are some of the things that clients, maybe pre-marriage and then even post-marriage, can do to prepare for what might be an unforeseen circumstance like this, right? We're in the business of helping clients prepare. What do they need to know about that?
Yeah. So the misconception is that only people with significant assets should sign prenuptial agreements. And that's just not the truth. I mean, any and everybody should be considering a prenuptial agreement. And the reason for that, it's not to say, I think we're going to get divorced. A lot of people are offended by the term prenuptial agreement. And the meaning behind it is not for it to be offensive or for the parties to believe that they're going to get a divorce. The benefit of a prenuptial agreement is the two of you can look at each other while you're in love, while you're excited to start your life together, and say, should this end, this is what we believe is fair and equitable. And you can agree to that on the front end. So if something awful happens, or, you end up hating each other's guts, there's nothing to fight about because you made those decisions while you were excited and in love. And so I always recommend, regardless if you work at McDonald's or if you are the CEO of Atrium Health, you should be considering a prenuptial agreement, because even if you have money or you don't, circumstances change, and prenuptial agreements are going to protect you regardless if you lose all that money, or if you might work for McDonald's when you get married, but then you find a business 2 years ago and you become a millionaire, right? It's to protect you long-term regardless of your financial placement at the time.
So I think a good example there, another analogy might be life insurance. People buy life insurance not because they plan on using it, but they hope that if something ever does happen, like an untimely passing or an untimely death, that the life insurance is reliable and there, right? It's a safety net, it's a parachute. The other one would be homeowners insurance. Most people buy a home thinking that it's never going to burn down or nothing terrible is ever going to happen to it from a devastation perspective. Things do happen, and most people are always super excited that they have their homeowners insurance when those things arise. So the prenuptial agreement makes a whole lot of sense. When does a postnuptial agreement make sense? Is it kind of the same mindset?
The same mindset. Postnuptial agreements are less common. You don't see them often, but that could be that example I just gave. You worked at McDonald's when you guys got married, but now you guys own a business and it's worth $1 million. You're still in love. You know that divorce is possible, and you say, hey, our business is doing pretty well. I think we need to address what's going to happen if this were to happen. And you can always come in and get a postnup. And the good thing about prenups and postnups is they can always be modified as long as it's agreed and signed by both parties. So as things change in your lives, just like you would edit a will or modify a will, it's the same thing with a prenuptial agreement. It can be modified as long as both parties are in agreement to modify it.
Got it. So last question that I have as we begin to wrap things up here, I'm sure our listeners are a little bit overwhelmed, at least I am. When it comes to the divorce process, can you share any experience that you've had with clients that are working with or have brought their financial advisor or professional to the table to help assist in the process?
Yeah, so it is common, and with people with larger estates, to have what we call a forensic accountant to go through essentially all of their marital estate. Because like I was saying, right, I'm a lawyer. I'm not a financial advisor or representative, right? So there are some things that I don't know. If it's simple math, 100,000 minus 50,000, I can manage that. But there are cases where a financial representative does have to come in and take a deep dive into valuing the business, looking at all of your retirement accounts and seeing, okay, like I said at the beginning of the episode, you might have had 50,000 in your retirement, but that 50,000 has accumulated 15,000 in interest. Is that interest marital? Is it not? Those are things that they would bring to our attention that we can then address. So it is very beneficial if there is a significant marital estate, to have a financial professional involved in the process.
So as we wrap things up, and we appreciate you sticking with us, we know that this isn't the most exciting information, but it is a necessary evil just to prepare ourselves or anyone who's potentially, unfortunately, going down this path, right? Because information can be powerful and it can help you, or at least lead you in the appropriate direction as opposed to making a bad decision for yourself and your financial future. So to summarize, one, we recognize that, hey, finance is a big piece of what leads couples to get divorced or separations, right? And we referenced a couple articles. We talked about how assets are split based on titling, either pre-marriage, post-marriage. Obviously, that's different per state, so just keep that in mind. We talked about the business owner scenarios. What happens to your business or the equity in the business or even the assets in the business if you are going through a divorce and separation? How cash flow can be impacted, right? Whether you were saving together and then also post-separation, if there's some sort of disparity between income between both spouses, adding in children makes it even more complicated from a alimony and child support standpoint. And then, of course, the costs of it all, right? If you're going to go through this process, do your due diligence to get and understand that, hey, there are going to be attorney fees. There may be attorney fees for two attorneys if you and your spouse cannot be amicable and realistic with the division of the assets. So again, if you find yourself at a point in your relationship to where counseling and marriage therapy is not working and you're going to go solicit a family law attorney, just understand that there is a cost that comes with it. And depending on how you and your spouse communicate and work through this, it could be either more costly or less costly. Because let's be honest, ignorance isn't a defense in the court of law, so you need to be aware of that. Now, Sabreena, we're very grateful that you were part of our episode today. You provided a ton of insights. You've been an amazing resource, not only for us with this episode, but hopefully to our listeners as well and anyone who is directly being impacted by divorce. And for those of you who want to learn more about Sabreena and her practice in the state of South Carolina, you can go to her website directly at www.sbarbozalaw.com.
So wrapping up the episode, we hope that all of the information here today has given our listeners a real-world look into the financial decisions that come along with divorce. It's not an easy season of life, but with the right knowledge, it doesn't have to be financially devastating.
Whether you're in the middle of separation, thinking about one, or supporting someone going through it, our hope is that this episode gives you clarity and confidence. And also, if you're looking for a resource, we've put something together entitled, What Issues Should I Consider During My Divorce? It's a little checklist that you can reference as you navigate these uncertain waters.
And in addition to that resource, make sure to like, subscribe, share this episode with someone who may need it, and leave us a review. Your support helps us bring more powerful conversations like this one to all of our listeners.
And if you got a topic or question you'd love for us to cover, head to www.genesiswealthplanning.com/AMA, and who knows, you may be featured on our next episode. See you next time.
Thank you for joining us this week on the Financial Fortitude Podcast. We hope you enjoyed the show and learned something along the way.
If you're looking for financial guidance that is personalized to your specific needs, we're here to help. Visit us at www.genesiswealthplanning.com to book a complimentary consultation.
That's it for today. Make sure you subscribe so you don't miss out on future episodes. And as always, please share with others you feel could benefit from the show. See you next time.
This podcast is for informational purposes only and is not to be construed as tax, legal, or investment advice. Although the information has been gathered from sources believed to be reliable, please note that individual situations can vary. Therefore, the information should be relied upon only when coordinated with individual professional advice. Guest speakers and their firms are not affiliated with or endorsed by Park Avenue Securities, Guardian, or Genesis Wealth Planning LLC, and opinions stated are their own. Guardian, its subsidiaries, agents, and employees do not provide tax, legal, or accounting advice. Consult your tax, legal, or accounting professional regarding your individual situation. All investments and investment strategies contain risk and may lose value. All scenarios and names mentioned herein are purely fictional and have been created solely for educational purposes. Any resemblance to existing situations, persons, or fictional characters is coincidental. The information presented should not be used as the basis for any specific investment advice. Michael Acosta and Brady are registered representatives and financial advisors of Park Avenue Securities, LLC, PAS. Securities, products, and advisory services offered through Park Avenue Securities, member FINRA, SIPC. Financial representative of the Guardian Life Insurance Company of America, Guardian, New York, New York. Park Avenue Securities is a wholly owned subsidiary of Guardian. Consolidated Planning Group, Inc. and Genesis Wealth Planning, LLC are not affiliates or subsidiaries of Park Avenue Securities or Guardian. Michael Acosta's California Insurance License Number 0M50974 and Brady Hemmerly's California Insurance License Number 4353077 7237198.17 expiration 927.